Hello and welcome to Season 2, Episode 1 of ARBinBRIEF. My name is Olga Sendetska. I am part of the ARBinBRIEF team and I practice with Freshfields in Frankfurt. I have the pleasure of moderating today's episode and providing you with a few words about ARBinBRIEF. It offers a practical video guide on handpicked arbitration issues and showcases talented arbitrators. ARBinBRIEF is produced in collaboration with ARBinBRIEF Pledge and Delos Dispute Resolution, and Season 2 is sponsored by LaLive. Today, we are talking about arbitration tactics and are joined for the discussion by Sally Kotb from Dubai, who is a partner with 𝗔𝗿𝗕𝗏 and Partners, and Laura Cundari from Vancouver, who is a partner at Blake's. Thank you, Laura and Sally, for joining. Now, perhaps let's kick off right away and start with the basis for our discussion. Laura, could you tell us what are arbitration tactics?
Sure. Thank you, Olga, and thank you for having me on this episode. So starting just at the basics, the term arbitration tactics in my mind just refers to the specific steps that you take to achieve your ultimate strategic objective in the arbitration proceeding. So for example, a tactic in disputes is often to try and control the timing of disclosure of key documents, saving something for cross-examination, for example. Another tactic might be bringing every conceivable type of procedural motion in an effort to delay the proceeding or increase costs for the opposing party.
Now, following up on that definition right away, as arbitration practitioners, we usually say that arbitration is a unique dispute resolution process. So my question is, are tactics in arbitration different than what lawyers would typically do, for example, in court proceedings?
I would say yes, or at least they should be for a number of reasons. So first of all, your arbitrator is working with the parties from the beginning of the proceeding, and both parties are typically trying to position themselves as the reasonable party. Second, the cost consequences are typically much more significant in arbitration than in court, with full indemnity costs typically being awarded to the successful party. And actions that add time and expense to the proceeding may play into a costs award. So the parties are cognizant of that. These first two reasons really motivate the parties, in my experience, to act reasonably and cooperatively, and they're not typically in existence in the domestic courts, at least in Canada. Finally, the element of surprise is largely removed in the arbitration process because it generally requires disclosure of the key elements of the case and documents in advance of the hearing. Whereas in a court setting, there's disclosure of documents and there's discovery in advance of the hearing, but the full legal theory of the case may not be evident until the closing argument. And often as counsel, I can remember sitting there trying to figure out what the strategy or what the ultimate position of the party was. In arbitration, you know that going in. And so that changes the way you approach the proceeding.
That's definitely super interesting. And I wanted to also tag on to what you've already said. You've noted that, well, in Canada, we do a certain thing, right? So something that is interesting to our international audience is comparison of practices between jurisdictions. So it would be great if you, Sally and Laura, would say a few words and whether you think that the tactics used by counsel differ depending on their jurisdiction of admission and the legal culture that they come from. Is that true? Have you seen any evidence of this in your practice?
Thank you, Olga, for this question. And I did definitely see this happen in practice. I believe that tactics generally are dictated by the procedural rules and ways that are available to maneuver them. So, for example, in the UAE, where I practice under the federal arbitration law, a party is entitled to challenge the tribunal's jurisdiction before the local courts. So we've seen a lot of cases where parties have tried to challenge the tribunal's jurisdiction at very critical stages in the arbitration, for example, right before the evidentiary hearing, only for the purpose of frustrating the process. Another procedural rule that is also often misused in the UAE is in the context of nullification of arbitration awards. So one of the grounds upon which a party can challenge an arbitration award is if it violates public policy. And because the concept of public policy is not defined in detail under UAE law, we've seen cases where parties have tried to challenge an arbitration award on the basis that it violated the public policy of a different state. So I was personally involved in a case where the award debtor tried to challenge a Dubai-seated award on the basis that it violated the law of the state of Qatar, which was the law governing the substantive elements of the parties' dispute. Now, thankfully, in this case, the execution court in Dubai rejected the application for nullifying the award. It proceeded with enforcing the award and clarified that public policy within the meaning that is covered under the arbitration law only means the public policy of the UAE and not any other state. But definitely actions like that lead to significant delay in the arbitration process.
Yeah, and I would agree with everything Sally said. I find these differences tend to vary both in terms of the divide between common law and civil jurisdictions, but also in terms of the home state of the attorneys or the counsel at issue. So, for example, Canada and England are very aligned in terms of both being common law jurisdictions. But the way, for example, that witnesses are prepared will vary greatly as between an English barrister and Canadian counsel, particularly if both have primarily practiced in the courts. So in Canada, it would not be out of the ordinary in a court proceeding or a domestic arbitration even to ask a witness that's testifying how they worked with counsel to prepare for their testimony. And if you ask that of a witness who's being led by an English barrister, you're, essentially on the line of questioning the barrister's ethics. You'll also see differences in the ways that expert evidence is proffered based on the jurisdiction of the counsel representing the parties. For example, how independent the expert is treated as with respect to counsel, and whether counsel anticipates that the expert's file will be disclosed. That varies by jurisdiction, and that will influence how counsel deal with the expert in the proceeding.
Got it. Thank you so much. That's super interesting. And I think that that kind of leads to also another question. Some of the arbitration tactics may be justified and within the limits of what is permitted by the procedural rules, but others may be prone to misuse and kind of tip over to what arbitration practitioners like to call guerrilla tactics. So maybe, Sally, could you perhaps help us with defining what guerrilla tactics actually are?
Well, it depends really on the circumstances of each case, but I think guerrilla tactics can be simply defined as procedural gamesmanship, where a party tries to append the procedural timetable or to gain a strategic benefit by way of deceitful means, really. And this can take many forms, from seeking to introduce new evidence into the record of the arbitration at the later stage of the proceedings, or repeatedly sending unsolicited letters, presenting motions, for example, outside of the procedural calendar, raising new arguments or producing new experts late in the day as well. All of these are forms of guerrilla tactics. And as we mentioned earlier as well, we also see guerrilla tactics in the context of enforcement, and also threatening of not participating in the entire arbitration process is also a form of guerrilla tactic.
It's interesting that you say that it depends on the circumstances of the case. So the decision is therefore ultimately yours when you sit as an arbitrator to draw the line between the two. So when you sit as an arbitrator, how do you differentiate between counsel genuinely pursuing their client's interests and, on the other hand, efforts to obstruct or delay arbitration proceedings? Is it kind of something you have to foresee in order to be able to recognize it?
Well, I think as a first port of call, it's very important for an arbitrator to understand his procedural rights under the relevant rules and also of the lex arbitri. It's also very important for arbitrators to engage in a meaningful dialogue with the parties early on, to understand, for example, whether a certain delay in respect of a certain procedural milestone is genuine, and whether there are real reasons behind it, or it's only advanced by way of bad faith just for the purpose of frustrating the procedure. So I was very recently involved in a case where one of the parties was a government entity, and this entity was facing a lot of difficulties producing certain documents that were ordered by the tribunal. And the reason behind it was there were a lot of restrictions imposed by national security, and the fact that these documents were sort of hosted or held in certain servers that are referred to as the red zone servers, and they can only be disclosed by that government entity upon approval of certain officials in the government. So unfortunately, situations like this do happen, but they're just really inevitable. And I think in cases like that, a tribunal needs to take a proactive approach, either to direct the claimant to accept a slight delay in the process in a view of obtaining a full evidentiary record, or just to go ahead with arbitration and proceed with issuing the award based on the existing evidentiary records.
Laura, would you also agree, and could you maybe share your own experience on this point?
Yes, I would agree with what Sally says about the need to assess the true cause of delay. In my experience, it's extremely rare that counsel would be dishonest with the tribunal, and sometimes what may be perceived to be tactics are just the result of unreasonable clients. So as both an arbitrator or counsel, this is one of the reasons I think it's very helpful to have the parties themselves attend that first procedural conference, so that the nature of the process can be explained to them. Their counsel will likely do this as well, but I do think it is different when it comes directly from the tribunal to the party.
Now, I think this might be a good point to also discuss the tools that are available to arbitrators to set limits on counsel's tactics. And I wanted to specifically take you to the Delos arbitration rules because they have a rather special provisions in Article 1. So specifically, Article 1.2 sets out that the principal purpose of the rules is to enable the tribunal, the parties to the dispute, and Delos to deal with cases fairly, expeditiously, and at a proportionate cost. And then Article 1.4 requires the parties and representatives to act in good faith and assist the tribunal to further that principal purpose. Laura, would this provision be helpful to arbitrators when trying to ensure that the parties' tactics in arbitration are not excessive?
Yes, the combination of that rule with also Article 12.2 and 12.4 of the Delos rules gives the tribunal very broad powers to determine the procedure and to manage the proceeding effectively. So typically these types of rules and the arbitrator's authority won't be unilaterally invoked by the tribunal, but where I see them typically coming up is part of the analysis on, for example, an application within the proceeding. An example of that might be an application for admission or exclusion of certain evidence or production of documents. You'll see the arbitrator invoking these types of rules. And these objectives, of course, are perpetually in the arbitrator's mind as guiding principles as they work to ensure a fair and efficient proceeding. All of this is best practice, but these rules give the parties a good reference point because they specifically set out these principles in writing. They institutionalize it, and they also make it easy to refer to for parties that are new to arbitration or trying to understand sort of all of these unwritten rules.
Sally, maybe a follow-up question to that. Outside of the powers set out in the arbitration rules, would any other rules be helpful to the task of determining the limits of arbitration tactics and what is acceptable?
Well, as you said, Olga, in addition to the relevant procedural rules, it would also be helpful for tribunals to consider the ethical rules of jurisdiction in which the parties' legal representatives are admitted. It's also helpful to refer to the IBA guidelines on party representation of 2013. And as a matter of best practice, it's always helpful for tribunals to remind the parties early on to act in good faith, engage in a fair play throughout the arbitration process. And this is particularly relevant in jurisdictions where the concept of good faith and fair dealing are prevalent and form really the basis of a party's contractual relationship or business relationship in general.
Thank you so much, Sally and Laura, for a very insightful discussion. We also thank our partner organizations, Delos and ARBinBRIEF Pledge. Delos Dispute Resolution is an independent arbitral institution established in 2014, and ARBinBRIEF Pledge establishes concrete and actionable steps to increase the number of women appointed as arbitrators with the ultimate goal of full parity. The sponsor of our second season is 𝗏. 𝗏 is an international law firm with offices in Geneva, Zurich, and London, renowned for its expertise and experience in dispute resolution. To see future ARBinBRIEF videos on hand-picked arbitration issues, please follow us on LinkedIn and like and subscribe to our YouTube channel. We would love to hear your comments and feedback, and you can register for our next episode on arbinbrief.com. And we look forward to seeing you there.